Mr. Shashank Pandey from Vidhi, uh, Vidhi Center for Legal Policy. His paper is titled Dignity Denied, Benevolent Ableism, Political Rights, and the Constitutional Exclusion of Persons with Disabilities in India.
Hi, am I audible?
Yes, you're audible.
Yes, good afternoon to the esteemed panelists. And on the onset, I would just like to express my apologies for not being able to attend the conference in person. And also, just another disclaimer that because I often use screen reader, so if there is any interruption between by my screen reader, so please excuse that. So I don't have a presentation, so I'll be focusing on the pointers that I've made. I'll try to be brief, try to be within my time span. Uh, so I'll start with before going into the academic part and the more legal doctrine aspect of why the dignity denied is an aspect for person with disabilities in general and person with psychosocial and cognitive disability in particular. I would rather like to underline the significance of the subject matter from a more policy and political perspective because that underlines why there was a need for such doctrinal research or why there was a need for such academic deliberation. And there are few instances that I would like to quote, beginning with the foremost, which is the invisibilization of the disability during the deliberation of backwardness during our constituent assembly debate. Because when our the constituent makers were deliberating upon the aspect of backwardness with Dr. Ambedkar at the helm of it, many identities, sub-identities, and even intersection identities were pointed. Unfortunately, disability was something which wasn't there in their deliberation of what would constitute a backwardness, and hence the obvious outcome of that is that we see that there is no mention of disability in the entire fundamental right part of it, apart from just one article within the DPSP. Especially, there is no mention under Article 15 or 16, wherein identities are mentioned. So that's one thing. The second thing that happened, because there was this complete absence of deliberation on the backwardness of this vulnerable community. So there was also naturally invisibilization of this community. And whenever there is invisibilization of any identity group, the foremost uh, the foremost right that is often infringed is your political right, because often the other rights directly flow from your political and civic right. And what I mean by political right is very expansive in this, but in this paper I have limited that scope by only looking at the capacity to participate, to contest the election, and also the capacity to be part of the voting process. So within the paper, that's the limitation on the political right that has been deliberated. But in the wider context, the political right is far more wide from which other rights flow. So that was the other aspect, that often that absence of deliberation in the Constituent Assembly resulted in the invisibilization of this community. And unfortunately, that has still continued in some form. We have developed, the doctrines and the different understanding of disability, which I'll deliberate later on in my presentation. But unfortunately, it does materialize in some form or the other, and often in a very paternalistic form. So that was the second component. And the third component, which unfortunately historically led to this deliberation, is uh, that there has been no attempt since independence, unfortunately, to actually make to identify the person with disabilities within the political discourse. And the most obvious example is that there is no official data set that we know of lawmakers with disability, because the official documentation, which is the nomination form and the affidavit that is filed by the candidates in the general and the state assembly elections, doesn't have a column on disability. So historically, we don't have any official data per se of who are the lawmakers who have been in our houses, in the parliament and the state legislatures, who identify themselves as disabled. And this directly there is obviously this direct absence of any identification of any leader, and then the natural flow from that of from that is that there is also no leadership to look at. So that is the more underlying political and policy issue that warranted why I sort of deliberated in this particular issue. Now, what I mean in this paper by dignity denied, and so I look at it from what are the exclusions of persons with disabilities with cognitive and psychosocial nature from a both constitutional and statutory perspective. What has been the outlook of the outlook of the government and also the courts in terms of what they have been deliberating when it comes to political rights of persons with disabilities, and how do we actually understand the nature of this right from a dignity principle, and therein I adopted the Waldron's principle of dignity, right? I'll start with my sort of core argument, which is that inclusion from a political life is not always overt. It often sort of operates in a very indirect fashion, indirect form, and often is materialized or operationalized rather through the exclusion by providing the procedural mandates that exclude a certain degree of individuals. And that is what the laws, the statutory laws in our states do. That often in multiple state local legislation for the third tier of governments, there will be procedures that are there which are providing certain mandatory provisions which a person with disability won't be able to suffice, and hence there is this by default exemption, by default exclusion of that. And often the argumentation that is taken is very functional oriented, which is why that the duty or the obligation that is to be performed are in a nature which is very functional, and hence this disability understanding is looked at from a very functional perspective. So that's the first limitation of our political laws. Then we come to the second aspect, which is what is there even in our constitution, which is under Article 102, under Article 91, and under Article 33 to 6, which does mention phrases like unsoundness of mind or disqualification of person with disability persons on the basis of unsoundness of mind. That's what mentioned in the constitution. Interestingly, when I mentioned that there was no discussion on the backwardness aspect from a disability perspective, there was also no discussion on this aspect. So whatever the documentation that we do have on this aspect is observations from two of the members of the Constituent Assembly, one of the member being Naziruddin Ahmed, who interestingly made a very, sort of a very progressive deliberation or uh, input on the phrase of unsoundness of mind. He said that in some capacity, from the vantage point that we are in, uh, every person is sort of unsound in some form. Although this, he just spoke on this limit, but the ramification that his statement makes is what we understand today is what we call social model of disability. That often disability is not inherent or individualistic in nature. It's caused by what is being posed by the society in general, and the interaction of this person with the barriers that is being put by the society is what is causing the disability. So what Mr. Nazruddin back then mentioned about this, understanding of unsoundness from a very social perspective is exactly what we have today. Unfortunately, that didn't lead to any materialization. And the second point, which sort of speaks of the other extreme of the spectrum, was another observation made by another Constituent Assembly member, and he asked for complete, exclusion of person with unsound mind without there being any declaration by the court. So currently we have this safety wall which says that this unsoundness of mind has to be declared by a court. Only then a disqualification can occur. And the argument by the member was that how many people in this country back then are actually being declared unsound by the court. Even the people who are in then at that time in asylum are not so declared by the court. So do you really think that this provision is actually is going to be effective? Now that was another extreme point of view from a very exclusionary perspective, but his rationale was something which was very practical, because if you have this declaration by the court of disqualification, how many people are actually and who has the onus of such disqualification. And this is something which even the courts have not been able to provide the answer clearly from. The response that we do have from court is somewhere of 2008 judgment by the Apex Court in Hari Singh, wherein they equated this unsoundness from a political perspective or political right to the mental illness. That was what they equated with. Now, that leaves an entire community of person with mental illness from excluded from the political participation or being able to participate in the political process in terms of contesting an election. Uh, so that was the another limitation that we have. Now, unfortunately, our constitution, though adopted this unsoundness of mind and almost 150 other legislations also do use this unsound mind or insanity, these two phrases. But apart from the Contract Act of 1872, we don't have any such clarity on what this phrase means, apart from the criminal laws perspective, wherein this phrase and this there has been extensive deliberation on this phrase from a defense perspective. But how it operates in criminal perspective and how it operates in political right framework is a very different thing. And unfortunately, the latter part, which is from the political perspective, is something which hasn't been deliberated upon from a satisfactory perspective. Now, interestingly, even if we take the definition of Contract Act, you'll realize that Contract Act definition is very functional in nature, as in they do allow that if a person entering into a contract is in the ability to understand the ramification of what they're entering into, they do have the contract will be considered as valid contract. Now, whether we can stretch this understanding to a political right. So, Jeremy, and wherein the Jeremy Waldron's idea of dignity comes in, which is that is dignity is recognition of individual as responsible agents, and this responsible agent principle of dignity of Jeremy Waldron is what I have sort of utilized to argue that often, even when you stretch the understanding of what we have in contract law to political right, that does serve as an empowerment from a democratic principle. Right. So that is one of the arguments that I have taken in this paper and have expanded upon. That it does serve to within the democratic principles. It does serve as empowering right to for person with disabilities. Now, the last part of it, which is understanding it from a disability perspective, wherein the idea of benevolent ableism comes. So benevolent ableism is something which is
Shashank, you have
inspired.
last 2 minutes.
Got it. So benevolent ableism is something which is inspired from benevolent sexism, the theory of Catherine Crenshaw, which often speaks of paternalism. So what we have right now in our political, the what we have right now for person with disabilities in political discourse is is operated from this benevolent ableism perspective, wherein this is operationalized by putting person with disabilities under the garb of guardianship or under the garb of protection to deny them the right. Now, a great instance which we saw last year was that person with disabilities were allowed to vote from home. Person with benchmark disability, which is person above 40% disability, were allowed to vote from home. But person with disabilities in general were not allowed. So for instance, person below 40% were not allowed. So the idea was that person with 40% above 40% need more protection, and hence they should be given preference for voting from home. Now, what it meant was that the idea was to, which was something which is visible from the documentation that was published officially, that they are not allowing a person with disabilities the right, the experience of going into the political into the polling booth to have that democratic, to be part of this democratic process, which is quintessentially a very basic aspect of dignity. So this was something that they thought is going to be substitute. So this was a provision of a substitution and not participation. That's one of the argument, and there are a couple of other instances which is cited in the paper that elaborates upon this. And in the concluding part, I think the Supreme Court in the last 2 years, especially in the Vikas Kumar versus UPSC, wherein it elaborated upon the how reasonable accommodation is itself a fundamental right, and it identified reasonable accommodation not just in the Article 14 but Article 21, interestingly. And reasonable accommodation is very individualistic in nature. It's different from accessibility, which is universal in nature. Reasonable accommodation is individualistic, and when this dignity principle is inspired, this reasonable accommodation inspired from dignity principle is applied on a political right of person with disabilities. We see that often there are there is structural exclusion of person with disabilities on three fronts. First, the non-recognition through constitutional exclusion and statutory exclusion. Second, the structural exclusion through the procedural mandate. And the third, operationalization of the governance system through benevolent ableism that often causes indirect discrimination. So that's three sort of concluding remarks or identified, factors that I have dealt in this paper. So that will be all.
Thank you. Thank you, Shashank, for your presentation. I think we'll straight away open the floor for questions. I must tell you, I thank you for so clearly asserting that it is the society or the polity which is diseased, which is applying the medical model to invisibilize and exclude the peoples with disability from participating in the public realm. Probably the virus is in the society, and that is something that when we are thinking about anti-discrimination law, we should remember.
Correct.
Yes.
Yes.